Hello, everybody. Today we are with one of the most eminent figures in Indian judiciary, former Supreme Court judge, and one who delivered such important judgments as the 2G Spectrum case. Asok Ganguly will talk to us about the new Aparajita Bill that has been passed in the West Bengal Assembly. Welcome, sir. Sir, do you think that this new bill is a well thought out bit of legislation that can actually deter future crime against women? Or do you think this is, as many say, a knee jerk response to the public outrage?
I think that this new Aparajita Bill, tabled by the Chief Minister, is a kind of a political gimmick to divert attention from the present huge unrest over the case of rape and murder of a young doctor in Arjikar within the premises of the state hospital, and the manner in which a cover-up is organized by the by the state agencies. To divert attention from that, the Honorable Chief Minister of West Bengal has sought for this device. Because I think, and it's not only my thinking, the thinking of many criminologists and sociologists, that harsher laws do not reduce the rate of crimes. This is proved worldwide. And today, 135 countries in the world are abolitionists, in the sense that in those countries, there is no death penalty for any crime. In this country, death penalty has been upheld by Supreme Court in the Bachchan Singh's case. But in the Bachchan Singh's case, Supreme Court has made several guidelines for which it is very difficult to impose death penalty if those guidelines are rigorously followed. I'll give you an example. One of the factors which the Supreme Court has considered is the provision of Section 235(2) of Criminal Procedure Code, which is also retained in the present Bharatiya Nagarik Suraksha Sanhita as 258(2), Section 258(2). This section says that the accused has to be heard on the question of sentence. Now, this has been interpreted by Supreme Court as to involve a bifurcated hearing. One hearing on the question of proving the guilt of the accused beyond reasonable doubt, and the next hearing is on the question of sentence. That includes various factors apart from those which were considered at the time of proving his crime. This should also be an equally bifurcated, irregular, full-fledged hearing. The second aspect of the matter is Section 354(3) of the CRPC, old CRPC, which is 393(3) of the present Bharatiya Nagarik Suraksha Sanhita. There also, in cases of death sentence, the court has to give spatial reasons. Spatial reasons would mean the court has to weigh and balance the aggravating and the mitigating circumstances. The aggravating circumstances relating to the crime and the mitigating circumstances relating to the criminal. His age, whether the criminal, so-called criminal, is beyond reform, whether he is a threat to society or not. These are the two mitigating circumstances. The Supreme Court has said that these two circumstances have to be proved by the state by adducing evidence that he is a threat to society, that he is beyond reform. unless the court, the prosecution crosses this hurdle, death penalty cannot be imposed. This is in those cases where death penalty is an alternative sentence. Here the amendment has been made. I have the amendment before me. In some areas, the amendment which has been made, that is section 64 of the present Sanhita, what is this? Bharatiya Nyaya Sanhita, which is previously India Penal Code. Section 64, there, punishment for rape. The new Aparajita Bill has introduced life imprisonment or with death and fine. There is an alternative sentence provided. In such alternative sentences, I have said these provisions of special reasons, hearing the accused on the question of sentence have to be gone into. But in another case, where section 66 of the present Bharatiya Nyaya Sanhita has been amended by the Aparajita Bill by saying that person committing an offence of rape and inflicting injury which causes death or causes the woman to be in a vegetative state, here only death has been prescribed as the penalty. That is mandatory death penalty. This mandatory death penalty concept has already been outlawed by our constitution bench of Supreme Court in the case of Me Too and the state of Punjab, 1982 Supreme Court. That's a reported 5-bench judgment, unanimous judgment. The court held where you are not giving the judge, because death penalty cannot be imposed by the government or the executive. It's imposed by the judiciary. Where you are not giving the judge an option to either give death penalty or give life sentence. There, this foreclosing of option is something which is discriminatory, violative of Article 14 and 21. So, in view of this judgment, this law, this clause, this 66 punishment clause, which has been amended under the Aparajita Bill, is completely against the Constitution. And against, I shall want you to consider the international thinking on mandatory death penalty. You can read this.
So, given that this Aparajita Bill has been framed as a part of the concurrent list, given that it is in the concurrent list, it cannot be in conflict with any central legislation, let alone the Indian Constitution. And since you say that it is in violation of the Indian Constitution, there doesn't seem to be any chance of it seeing the light of day. Would I be correct in assuming that, sir?
Should be, because it has already been declared a mandatory death penalty provision has already been declared otherwise the Constitution by Supreme Court. That is also the international position, which has been accepted by our Supreme Court. Since it has been accepted by Supreme Court, you repeat this same mistake, it will be similarly, even if it is assented to by the President. President can refuse its assent on this ground. Even if it is given, the court will always strike it down.
Now, sir, many people, particularly I have talked to women activists, social activists, legal activists, and lawyers, they're almost unanimous in saying that this is essentially a very regressive law. And do you also see it as a very regressive law?
Yes, it is. Because the world is moving towards an abolition of death penalty. Here, if you introduce death penalty for new offences, I mean, where you make death penalty a mandatory one, that is itself regressive. By death penalty, you cannot cut down the number of offences. Say, for instance, in Nirva case, death penalty was given for rape and murder. Has rate of rape come down since then? The answer is obviously no. In order to prevent rape, you must improve your standard of education, your social background. You must give more independence to women. There must be better empowerment for women. Respect for women can only come from a better sense of education. Education in West Bengal has struck a rock bottom. You see, the entire education system has been sold. Today, education system in West Bengal is the worst. I mean, since independence. The government is steeped into corruption in every field. Even in this case of rape and murder, I call it a state-sponsored murder, state-sponsored crime, because the perpetrators have committed the crime, but the state has a hand in protecting them by destroying the evidence. State agencies are involved in destroying evidence, and they are moving scot-free. Nothing is happening to them.
Are you satisfied, rather, with the way the case is progressing in the Supreme Court?
Sorry, I was part of Supreme Court at one point of time. I'm very, very mentally disturbed and unhappy, with great respect to Supreme Court. Because the way Supreme Court has considered the protests by the junior doctors and has asked them to go back to work, giving up their protest, and at the same time gave the state a chance to issue their powers, use their powers if the doctors do not resume duties. It shows that the Supreme Court is somehow or other is protecting the corrupt party. The administration is thoroughly corrupt, state administration. The Supreme Court is not understanding or sympathizing with the causes for which the doctors have come on the streets.
What should it do? What do you think, what do you recommend that should be done right now?
Supreme Court should not have interfered with the ongoing strike. They are raising a strike on a very legitimate ground. Their grounds have not been redressed. It is a democratic country. They are not resorted to violence. They are going on a very peaceful strike. I'm amazed at why Supreme Court has got into this. Supreme Court should have said that that is not part of the criminal investigation relating to rape and murder. So we are not concerned.
There is a feeling among many people that there was really no need for this Aparajita Bill given the existing laws in this country. And what was more important is the implementation of these laws rather than a fresh bill with enhanced punitive measures. Would you agree, sir?
I agree entirely. Already the provisions in the law are sufficiently stringent and quite harsh. But the law has to be implemented. Which law permits this kind of investigation by the police, which they have done in this case? Which law permits this way of the way the police have tried to destroy evidence? This is certainly against the law, but the police is getting away with all this. Police and the hospital. Which law permits that a fire has to lodge up 14 hours after the incident, and that too not by the hospital authority, but the crime has been committed within the precincts of the hospital? And the manner in which the post-mortem has been conducted, rushing it in order to destroy evidence, which law permits this? All the laws relating to investigation have been gone for a toss in this case. And you are talking of stringent laws.
Well, there's also this claim by the state government that they are ensuring by this bill, they are ensuring a speedier justice by reducing the investigation time to just 21 days and the time for the judiciary to 30 days. Is this really realistic? Is this viable? Can this really take place given our infrastructure, given our manpower?
No, certainly not realistic. To complete an investigation in 21 days is very, 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 very difficult. In that case, the police will do a very bad job.
In criminal law, one has to prove, that thing is with
Beyond reasonable doubt.
reasonable doubt.
Mm.
So that kind of reduces the scope when you reduce the time limit, does it, sir?
No, but the way today the police hardly cooperates with the trial. You see what happened in that Kamduni case. Almost more than dozen times the PP has to be changed. PP is appointed by the state. Why the PP one after the other is changing?
14 times, I believe.
14 times, yes. I mean, you cannot completely shut your eyes to reality, what is happening, and come out with some half-baked provisions.
So what do you think is going to be the fallout of all this? I mean, as I'm just asking you, not just as a former Supreme Court judge, but as an eminent citizen.
Have to take up the fight against this huge corruption, maladministration, which the people have taken up.
And do you think anything can come out of this bill, or it is bound to be?
This bill is virtually a non-starter. This bill will not create any impact on, and in any event, the present crime can't come under this bill. The crime was committed prior to the bill being tabled. So present crime can't come under this bill.
And we've seen that its passing in the state legislative assembly has not really quelled the protest either.
That is how that may be their strategy. I don't know. They are also afraid, the opposition, that if they oppose the bill, they'll be painted as promoting rape. They're afraid of that backlash.
So thank you so much. Is there anything else you'd like to say on this matter, which we would love to incorporate? Thank you so much for your time, sir.